Hello, YouTube, my old friends. I've come to talk with you again. My name is Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here. A question from a YouTube user. We're just going to call her Carol, because I don't know if that's a full name, and I don't want to find out. Carol asked us as follows. Hello, Vince. Hello. I tried to make it to the live stream, but I didn't make it there. Not a problem. Here are my questions. If my case is dismissed at summary judgment, is there a way, or is there any way to appeal that decision? Yes. If there's legitimate grounds for appeal, you certainly can appeal. Yeah, absolutely. And listen, judges are not infallible. They certainly make mistakes in their decisions. They make mistakes in how they provide a logical foundation for their decisions. That happens. Like, it certainly could be appealable. The question goes on. If my case is dismissed, is that generally considered the end of my client-attorney contract? Depends on the contract. So some firms will say, hey, listen, we don't do any appeals work, ever. Or, and this is much more common, there's firms that say, hey, we don't handle appeals work unless there's somebody appealing something we've won for you. That's really common, right? And they obviously have reason for that. They won you money, and they want you to collect that money so they can get their money, their percentage. So often, a lot of firms, if there's an opposition to an appeal, like somebody else's appeal that they need to oppose, they're all in. They're like we get excited about that. We have an appeals guy. It's, the whole thing, and we're like, yeah, defend the verdict. Let's go. Like that's fun. But a lot of times firms are going to say outright in the retainer, like, hey, if there's a negative decision here, we don't do appeals work, because appeals work is super expensive. Like in New York, some appeals, you might have like 10, 15, 20 grand in printing costs, because you have to have a special super experienced printer print everything in compliance with the weird esoteric demands of the appeals court, right? This is kind of like a pocket industry made up almost just by the edicts of the state and the appeals court and everything else that just wastes people's money on these appeals. So you get firms who say, yeah, you could appeal, and if the appeal is successful, we'll pick up the case again, but you got to go hire the appeals people if you want to appeal. So it depends, and there's you could have a retainer that says we handle all appeals, right? You could work with a firm that just says, yeah, any negative thing, we're going to appeal it, as long as it's like a viable grounds for appeal. Those firms exist too. I doubt it, but they could be out there, is I guess what I'm saying. And the question goes on. If I observe other acts of discrimination in my workplace, would it be best to bring those examples into my own case of discrimination, or ignore them and just focus on myself? So if they're useful evidence, okay, I'm going to assume you have not yet had a negative determination at the summary judgment phase, because you're asking about like things to include in your case still. So I'm assuming your case is still happy and healthy. And so the answer there is, if you see discrimination going on and it is useful as a form of evidence in your case, even if it's directed at someone else, if it's useful as a form of evidence in your case, you may very well want to have a conversation with your counsel about including it. If it's not useful as evidence in your case, then it may not be useful, but that's a determination for you to make with your counsel. Certainly that is a fact-driven decision. You're going to need to deal with the nitty-gritty, the specificity of what's going on there to really get into if that is or is not useful for you. Now, I will say this. You were talking about appeals earlier in the question, and if you've already had a negative determination at summary judgment and you're seeing new acts of discrimination, if those new acts of discrimination were aimed at you, they could then be grounds for a new, fresh claim that would not have been dismissed in that summary judgment finding against you, right? So keep an eye on that. If they're doing something else to you, some additional discrimination or retaliation to you, you're the victim of it, then that would be a potential new claim. And you now have the decision of, hey, do I pursue this appeal for my old claims, or do I bring this new claim built on these new events forward instead? And what's the best path for me? And you got to look at things like the risk of the two separate claims. Appeals, it's a long road, it's a tough burden, whereas a fresh claim, the minute you're starting fresh, anybody's day, any given Sunday you might win. Like there's no you're not starting behind in any way. Like if you're fighting an appeal, that case has already been harmed, right? I think that's something people don't understand when they call attorneys. People call us up and be like, hey, I got the case for you worth millions. All you got to do, I have technically already lost it. All you got to do is appeal. Okay. Well, as tempting as it is that you add $50,000 in costs to what I have to invest in your case by losing it before you hire me, as tempting an offer as that is, possibly we may not be making an offer of representation, right? And I don't think people understand that. People are just like, yeah, it's an appeal. It's no big deal. Just do the appeal. It's like, you have already done damage to this case. This case has been harmed. It could, if it has a legitimate argument as to why it should be, appealable, could be rehabilitated, but like, it's not necessarily tempting to plaintiff side firms. Could be. I'm not saying, I don't know for a fact. I'm just saying it's in a tough place. That's why appeal shops exist, right? There's firms who just do appeals work, generally by the hour, but occasionally flat rate, not on a contingency, right? That's the other thing. People call you up and say like, hey, yeah, I did lose my case, but I'm still within the appeal window, so I want you to take my case for, let's call it like 15%. It's like, no one's doing appeals work. Like, if a firm didn't handle the case, like a firm might be handling your case and might handle the appeals work for you because they already handled the case and they want to like keep fighting the case. They believe in you. It's a great claim. They're in. But if you hired some other firm or did something on your own pro se and got the case dismissed, the idea that you're going to hire a firm on a contingency, highly unlikely. Highly unlikely. Why? We already touched on why to some extent. Like, okay, so you hired someone else. They lost the case. We'll all agree case was solid. Case was good to begin with, but they lost the case at summary judgment. And now you want to hire us for the appeal. On a case you already lost. It's going to cost us all these tens of thousands of dollars to get back to even ground zero where the case was solid. And then we still got to hope we win. So now I got to spend all this money just for the chance that maybe I could win your case. Tempting. So tempting, right? So like think about the context there and don't count on the appeal. Like the appeals really can be very expensive. If you're hiring specialized counsel, specialized printing, I want to say I think I've capped out spending about $70,000 on an appeal with like specialized counsel and the printing and everything else. Like we've invested huge sums in some appeals work. And listen, you got to do it. You got to do it. If you got a big verdict and that's getting appealed, one, you got to collect because you've already got, I don't know, 80, 90, 100 grand wrapped up in that case. But also like, it's not like you want to leave your client high and dry, right? You won the trial. The other side's appealing. Walk away from your client. That's not a feel-good hit. That's not what we got in this business to do, right? So, Carol, appeals work is a murky place. There's differences from jurisdiction to jurisdiction, certainly, even court to court. What goes on in federal court is different than what goes on in state court. There's all these things going on, all these considerations. But anyways, I hope that I went through your question. I hope I answered everything. I hope it provided value. If I did help, like, subscribe, comment down below. It does help me to help more people just like you. Take care, everybody.